Hi, everyone. Welcome in. I'm Carrie, and today we have a couple of case updates on ones that we've been following throughout 2024. The first one is Marcella Chittister. Okay, so if you don't remember the face or she looks familiar, this is the lady who was completely wasted and she slammed into the Swan Boat Club in Michigan. She unalived two children and injured their mother. Now, her trial date is set for March of 2025. She's 67 years old. She was charged with numerous felonies, and this all occurred in April of 2024. According to the court filings, she is seeking to have her case moved to a different court, and she wants some evidence removed from the record. By the way, thank you, Patty, for sending me a reminder on this update. I appreciate you, honey. Let's see. She was charged with 2 counts of second-degree red rum, 2 counts of operating while intoxicated, causing death, and 4 counts of operating while intoxicated, causing serious injury. Her victims were 8-year-old Alana Phillips and 5-year-old Zane Phillips. Her blood alcohol level was 0.18, more than double the legal limit in Michigan. Now, they recently had another hearing, and the judge gave the prosecutors until January 10th to respond to several motions filed by her and her attorneys. These motions included a request to move the trial to another court and a request for a hearing to discuss evidence she wants dropped from the record. This includes statements she made before she was read her Miranda rights, and according to court records, she has requested an evidentiary hearing to address that matter. So we're looking at January the 10th, and then that will be followed by another hearing on January the 17th. So I will mark my calendar for that. It's been a while since we watched this. So this is after the crash occurred.
To the parking lot, what happened? I don't remember.
This is police body cam video of Marcella Chittister moments after authorities say she crashed into a boat club in Monroe County during a 3-year-old's birthday party on April 20th. 2 children were killed as a result, and several people were injured. Thursday, a judge ordering the 66-year-old woman to stand trial on second-degree murder charges.
I thought I was driving up to the boat club, and evidently I was driving right to the pavilion.
Chittister's blood alcohol content was 0.18, more than 2 times the legal limit.
On a scale of 0 to 10, 0 being like you're stone cold sober, you can drive perfectly, 10 being you're passed out drunk, where do you think you're at right now? 7. A 7? Okay. Do you think you're okay to drive? I wouldn't want to drive.
The defense attorney blaming health issues, neuropathy, and a history of seizures for his client's actions. Despite her seizures and the medication prescribed to her, Chittister had been cleared to drive. In court, Mariah Dodds, the mother of the 2 children killed, took the stand. She recalls the last thing she remembers before the crash.
I was walking back to the table my children were sitting at as they were eating, and that was the last thing.
That was an older video, but it's interesting because they talk about how she had seizures or whatever. This lady has a history of drinking and driving, and she's known at that Swan Boat Club very well. And there's been people talking about how she was always had to be helped to her car or helped home. Apparently, she didn't live far from the boat club, and it was kind of her place to go. But we've got a lot of good footage on this, especially the footage of her backing out of her driveway. She was wasted, and just the way she backed out, she hit the neighbor's truck and then took off. So if you want to go back and check out our previous videos on this case, please do, because I do think this is one that I would like to follow when it comes up. And I hope they don't change the venue. I really do. All right, let's move on to another case. Okay. If you've been on my channel for a while, you know this was a big one for us. Jennifer Crumbley, the mother of Ethan Crumbley. He was the young boy who went and shot up the Oxford High School, unaliving 4 teenagers. Let me open up and show you their picture. It's the 4 children that lost their lives. Their names are Tate Meyer, Justin Schilling, Hannah St. Juliana, and Madison Baldwin. They range between ages 14 to 17. All right, so what's going on in this case? So here's the deal. Yes, she was found guilty. Yes, she's been sentenced. But apparently, she's no longer working with her whiny attorney, Shannon. Because the latest article, which I found here, which is dated December the 2nd, says that she has new attorneys. And they have filed a motion this past Monday for an acquittal and a new trial. They're arguing that her criminal trial was tainted from top to bottom. In a first of its kind, a Michigan jury in February convicted Jennifer on 4 counts of involuntary manslaughter for the shooting her son carried out on November 30th of 2021. Her husband, James Crumbley, was later convicted on the same charges, setting a new precedent for parents of children who commit crimes. These proceedings were tainted from top to bottom and were born out of prosecutorial overreach attempting to criminalize Mrs. Crumbley's non-criminal conduct, said her new attorney, Michael Desi. Apart from the improper decision to charge Mrs. Crumbley, she was denied a fair trial where the prosecution deliberately withheld from the defense key impeachment evidence and proceeding on, Kafkaskwe, inconsistent legal theories. I don't know what the word he is. Oh, y'all, that's a big word. Legal theories that work a grave injustice on the law. She was sentenced to serve between 10 to 15 years in prison. She's now 46 years old, and it was quite evident after watching the trial that their son was neglected. It was as if they definitely didn't put him first. He was just kind of like, I don't want to say he was part of the furniture there. They did things with him. They spent time with him, but God, he was treated almost like a pet. He wasn't front and center for them. So, for example, like she really loved going over to the ranch and riding horses, and Ethan didn't like to ride horses. So instead of trying to find something that they could do together, she would just leave Ethan at home. And I really do believe, I know that Ethan is completely, there's something not right there about that kid. That's clear. But I think what added to it was the fact that he was trying to get his parents' attention. More than anybody else, he was trying to get his mom and dad's attention. And that's why he did what he did. Okay, let's continue to read on because they're going to go into a little bit more in depth about why they're saying that this was done incorrectly or that she was convicted incorrectly. It says that she and James showed up at Oxford High School on the same day that he shot people in the hallways, and they discussed violent images that the 15-year-old drew on a worksheet in the classroom. But then they left shortly after. They didn't even stay. I don't even think that the meeting was 15 minutes. Now, Mrs. Crumbley's constitutional rights were further violated by allowing, this is what her attorney says, Mrs. Crumbley's constitutional rights were further violated by allowing the jury to convict her in the absence of a unanimous decision as to what crimes were committed. For these reasons, the court should grant a judgment of acquittal or, in the alternative, a new trial. He argues in a nearly 700-page filing, in part, that prosecutors gave school counselor Sean Hopkins and former dean of students Nicholas Ejak cooperation agreements or proffer agreements to testify against Crumbley without sharing information about those agreements with the defense. Now, he also argues that those agreements with the prosecutor's office allowed Ejak and Hopkins to avoid criminal charges in the case. Now, those two are going through their own hell right now. And I don't think that the counselor, Sean Hopkins, was at fault. I think he did everything that he could up to what his authority was. I think that Nicholas Ejak completely dropped the ball. And there's a bunch of civil things going on, which I'll see if I can find those really quick and we'll talk about those next. A lot of people are being sued by the families. Now, an independent investigation into the shooting by Guidepost Solutions found that Ejak and Hopkins, the two people with the most knowledge about the decision to allow the shooter to go back to class after his meeting with his parents and school officials on the morning of November 30th of 2021, refused to cooperate with the investigation. And I'm saying the reason they did was they were trying to save their own butts, you guys. I feel like there was all this civil stuff going on, and it really did put those people in a tough spot. Now, the investigation also found that in certain critical areas, individuals at every level of the district failed to provide a safe and secure environment. They said in the motion for acquittal that Hopkins and Ejak were in the proverbial hot seat, hoping to avoid criminal prosecution for their acts and omissions related to the shooting. Now, to my knowledge, those two never had any kind of criminal charges, or even, it wasn't even discussed that they would be criminally charged. Did they fail to do their job? Can they be civilly sued? Yeah, but I can't see where they would criminally charge those two. By cooperating with the prosecution, these witnesses were hoping to avoid prosecution such that they had bias, motive, and personal interest to testify in a manner so as to shift the responsibility towards Mrs. Crumbly and away from themselves. Now, he said in a press release summarizing his request for an acquittal or new trial that Jennifer's right to a fair trial was further denied when the jury was instructed that it could convict Mrs. Crumbly even without a unanimous verdict. He states, "There's a reason why no parent in America has ever been held responsible for criminal acts of their child in relation to a school shooting. It is because Mrs. Crumbly committed no crime. The case should be concerning for parents everywhere." Now, of course, prosecutor Karen McDonald jumps back and says what she needs to say, but I'm not even going to put up what she says because I don't like her. We're not going to talk about what she said. Her and David, I don't like them, either one of them. Let me go back in here because I want to find. I had some updates on the civil suit, and now I can't find them. So bear with me just a second. So is this new attorney her appellate attorney? It didn't say appellate attorney. It just says her new attorney. Do you guys remember the one teacher? You guys remember this teacher right here? She was shot in the arm and she did survive. Well, she is suing the school district. It says a teacher who was injured in the 2021 Oxford High School shooting has filed a lawsuit against the district and several former school officials. Molly Darnell was the only adult and Oxford High School employee who was shot by Ethan Crumbly in the November 30th mass shooting that claimed the lives of Justin Schilling, 17 years old, Madison Baldwin, 17 years old, Tate Meyer, 16 years old, and Hannah St. Juliana, 14 years old. 7 others, including Darnell, were injured in the shooting. Now, Darnell, who provided emotional testimony during the shooter's Miller hearing, as well as during the manslaughter trials of the parents, she was shot in the left arm and had to use her cardigan as a tourniquet to stop the bleeding. In a lawsuit that she's filed, what month is this? In November of 2024, in the U.S. District Court for the Eastern District of Michigan, the Oxford Community School District, and the following 5 employees who were employed by the district at the time of the shooting are named as defendants. Sean Hopkins, the counselor, Nicholas Ejak, the dean of students. Now, these 3 are different and new to me. Timothy Throne, he's the school superintendent. Stephen Wolf, he's the principal of the school. And Kenneth Weaver, he is the superintendent who took over following Thorne's retirement. Anyway, the lawsuits allege that the school district and its administrators had a duty to protect district employees and students from foreseeable threats, including a mass shooting. Darnell, who works as an educational coordinator in the district, alleges in the lawsuit that it was imminently foreseeable that an act of gun violence like the mass shooting was a probable consequence of their neglect and an unlawful misconduct. Thus, the negligent and/or unlawful misconduct of the OCSD directly contributed to the harm inflicted upon various Oxford High School students and staff. Here's the thing on these guys. This is why this is also crazy, because one lawsuit triggers others. You know what I mean? Like if one goes one way and then the other, it's going to affect the way the others fall, or could, So it's interesting that you have so many different injured parties, and obviously you have some where the people have lost their lives. All these are different parents who are going in on these lawsuits against the school district for their lack of acting on what was seen. They saw the drawings he did of the guns and hateful material. He had a history of this type of stuff, and yet they sent him back to school. And my biggest thing has always been not that they just sent him back to class, but they never checked his backpack. The whole time that child was in the meeting with his parents and the school officials, that gun was in his backpack. So that's a big deal. He also had everything outlined in his notepad. I want to say he had it outlined in his notepad, in his backpack as well. All right, so let's go back to this, what I was reading here. Hopkins and Ejak testified during the Crumbly's trial that they met with the shooter and his parents the day of the shooting, and that they had no choice but to send him back to class because they could not remove him unless there was a disciplinary issue. Now, this I disagree with, because according to what Hopkins said, the counselor, he didn't have the right, but he looked upon Ejak, who was the dean of students, who did have the authority to say he does not need to go back to class. Y'all need to take him home, and they didn't do that. However, the truth is that school officials escalated the danger by releasing Ethan back into the school population from a place of safety and security. This is what the lawsuit states. They did this despite knowing Ethan's desire to inflict harm on himself and or others. These school officials compounded the danger of Oxford High School students and staff by releasing him from a safety zone with an unsearched backpack that contained the deadly weapon that the shooter used to carry out his or homicidal plans. The lawsuit claims that because of Ejak and Hopkins' deliberate indifference, terror, shock, excruciating pain, fear, trauma, severe emotional distress, scarring and disfigurement, wage loss, loss of earning capacity, all incurred future damages, including requiring ongoing mental health counseling. This is what she suffered. Now, she's the first district employee to file a lawsuit. The families filed the civil lawsuit against the district as well. Now, just to touch on this, because I'm sure you're aware, but Ethan Crumbly was sentenced in December of 2023 to life without the possibility of parole. So there's ongoing stuff with this that's not going away. I'm trying to think of what happened with that lawsuit. In early November, going back to Ethan's trial, the prosecutors urged the judge to reject the shooter's request to withdraw his guilty plea in the deaths of the 4 students. He's serving life for the Oxford High School shooting, but his new appellate lawyers want to start over, arguing that he had poor mental health when he waived his rights to trial and pleaded guilty to multiple charges at age 16. The Oakland County Prosecutor's Office, however, said that Crumbly falls far short of the Michigan legal threshold to withdraw a guilty plea. They say he cannot withdraw his plea merely because he has changed his mind. Crumbly signed a document acknowledging that he had discussed the guilty plea with his lawyers and that any questions were answered. In a separate filing, the prosecutor said that Crumbly's life sentence should also stand and not be changed. His appellate lawyers want the judge to hear new evidence of a turbulent childhood and exposure to alcohol during pregnancy. I guess his appellate attorney is saying, well, now that we've heard the trial of the mom and dad and we know that they were convicted, shouldn't that have some effect on his trial? Now, guys, don't you kind of see? It's kind of strange. I mean, you could do this whole loop-de-loop thing for forever. The prosecution, now this is so true. Prosecution wants to play on the fact that he's been convicted. And they did use that he's been convicted, right, in the trial of the parents. So now the defense attorney is saying, well, the parents were convicted. They're bad people. They didn't raise them right. So now we're going to go back and We want a retrial because we don't feel like he was 100% at fault. His parents took some fault in this. So it's interesting. That's why I guess I've never stopped following this case, is because I want to see how this all plays out. I do think they've opened up a can of worms here, and I don't know if they're going to ever be able to put them all back in the can. They're claiming that he had fetal alcohol disorder. Now, the parents also renewed their public plea for a broad investigation of the shooting. They said it could help Michigan schools keep students safe. Okay, well, that's good. It's in their favor if anybody at the school is looked upon badly for their inactions, is what I call it, regarding all of this. There were some notes also. Now, this was in early November as well. Oxford families pushed for subpoenas 3 years after Ethan Crumbley unalived 4 in school attack. So it says, although the gunman who unalived their children and his parents who gave him the gun are behind bars, the shooting victims are saying that their fight for justice is far from over. The victims' parents gathered for the first time without their attorneys alongside members of the Oxford Board of Education, the town's chief of police, and the county prosecutor's office, and other supportive parties to demand a full investigation into the events that led up to Ethan Crumbley's November 30th attack on the Michigan school. One of them said, this is not about identifying people to prosecute. That's what the Attorney General continues to get wrong on this. Well, this is part of the story. The bigger piece is to drive the chance to change the future. This is an opportunity to leverage the attack as a lesson learned. Fix what they did wrong so it doesn't happen again. The parents say that they are still in the dark about what could have been done differently leading up to that day, and they want accountability for the school district officials and staff who they say have escaped liability over their roles in the tragedy. Although the Oxford Community School Boards published a 590-page independent investigation carried out by the Guidepost Solutions, the parents said only a third of involved parties cooperated. Okay, now this is going back to EJAC and Hopkins. In certain critical areas, individuals at every level of the district failed to provide a safe and secure environment. School counselor Sean Hopkins and former dean of students Nicholas EJAC, the two people with the most knowledge about the decision to allow the shooter to go back to class, refused to cooperate with that Guidepost investigation. So they're trying to save their own ass. People that work as teachers, they don't make a lot of money. So it's not like, we're looking at the CEO of a big business that's going down. These are everyday people like you and me who struggle to make a hard-earned living. Only 51 of 143 current of former Oxford Community Schools employees responded to the company for the interviews. Really? The Guidepost, who was doing the investigation, asked the district to require employees to participate, but they did not do so. See, that's some BS, y'all. So how do we know what we don't know? Said Steve St. Juliana, whose 14-year-old daughter Hannah died in the shooting. What has the state done with the Guidepost investigation? They haven't even acknowledged it. And then another parent said there's a lot already out there that needs to be turned into something, to be turned into a countermeasure and turned into change. The group wants the state of Michigan to carry out and fund this investigation, and they want to use the subpoena power to force those who did not talk before to do so now. The majority of the information the victims' parents have learned about the shooting came from the trials of James and Jennifer Crumbley. And that's not the way it should be, you guys. Both Crumbleys were convicted. They were concluded as being responsible because they did not properly store the gun for their son. With that being said, I do want to say one thing. There was 4 people in that guidance counselor's office before the shooting. Well, actually 5, if you could include Ethan. You got the parents, and then this counselor, and the dean of students. Only 3 of those people knew that he owned a gun, or he had access to a gun, and that was the parents and Ethan. Prosecutors argued at both trials that the parents ignored indications that their son was depressed and crying out for help. They said that the Crumbleys could have prevented their son's actions if they'd disclosed that their son had access to a gun during the meeting. Now, they talk a little bit about the drawing. The victims' parents insist that the school was the 4th culprit in the massacre, And that's true. No government entity has weighed in on the Guidepost investigation or affirmed any of its findings. The Michigan Attorney General offered 3 times to review the school shooting, but the Oxford School Board rejected her offers. The Oakland County Prosecutor's Office, which had representatives at the Monday's meeting, gave multiple school officials confidential immunity agreements, including Hopkins and EJAC. So at one point I thought that the prosecutors were claiming we did not give them immunity. The state has basic immunity unless they're the ones pulling the trigger themselves. They're covered, they have a union. So Colorado changed their law after Columbine, that in cases about school violence, and that the immunity was not automatic. If you are grossly negligent, you could be held accountable. But that's Colorado. It's quite clear there is an epidemic growing, and it's not a matter of if, it's a matter of when this will happen again. Even if it can't be prevented, if we can come up with countermeasures, it's all worth it. And one person said that we're infatuated at looking at the tool instead of thinking, why are people feeling this way? Why are people feeling this way that they're wanting to do evil things? We're only looking at the gun stuff. Well, it takes two. It takes the gun and it takes them. So this case continues to be just full of controversy. And it's like a tree. There's so many branches involved in this one incident that occurred. And it's almost like Michigan is setting the stage for what's going to happen out there in the future. Now, we've also got this other child in Georgia whose father knew he had a gun, who did another shooting. And that I'll touch on that later on. There's been some updates on that. Not a lot, but we'll touch on that a little bit too. Not in this video, but in the future. So that's what I wanted to show you guys there. Our last update involves Corey Richins, the I call her the faux children's book author. Apparently she had a ghostwriter. So here's what's going on in her trial. Some new stuff has come up. Apparently there's a second employee that she had been talking to about procuring fentanyl from. So the Heber City Police have agreed to hand over a cell phone belonging to a former employee of Corey Richins who was allegedly asked to procure drugs for her in the weeks leading up to Eric Richins' death. The witness is William Hayden Jeffs. He worked as a handyman on several properties for Corey. So the sheriff's office detective said that they did interview Jeffs earlier this year, and he showed text messages allegedly corroborating his statement that Corey had asked him to supply her with fentanyl. He provided copies of the text to the investigators. He's the second employee that Corey is accused of asking for drugs before her husband's fatal overdose on March 4th of 2022. Now, Eric, her husband, had died after consuming 5 times the lethal dose of fentanyl. Summit County prosecutors accused Corey of poisoning her husband with a laced Moscow Mule, and they arrested her in May of 2023. They alleged that Corey purchased illicit fentanyl from an acquaintance who was a housekeeper she employed multiple times in 2022. Phone records show that Corey contacted the housekeeper several times in January of 2022. However, the content of the messages is unknown because they were deleted. The housekeeper told detectives, I thought they were able to get that stuff back. I thought once it was deleted, it's not necessarily always deleted. The housekeeper told detectives Corey called or texted her asking for fentanyl. So she asked an acquaintance to introduce her to someone who could sell her drugs, and the acquaintance gave the housekeeper a name and phone number, and a meeting was arranged. The court records state that the housekeeper met the individual at a gas station in Draper on February the 11th of 2022 and purchased between 15 and 30 pills believed to be fentanyl. So 3 days later, on February the 14th, Valentine's Day of 2022, the defendant prepared a sandwich for Eric and placed it on the seat of his truck with a love note. Shortly after consuming the sandwich, Eric broke out in hives and had difficulty breathing. Eric administered his son's EpiPen and then fell asleep. Prosecutors said he believed he had been poisoned, and he told a friend he thought he had almost died. Corey allegedly asked her housekeeper to procure something stronger in late February, and Eric died less than a week later. The search warrant, signed earlier this month, does not indicate when Corey may have contacted her handyman for the fentanyl. Jeffs is 35 years old, and he died in a motorcycle accident on September 30th. Oh, wow, I didn't know that. His cell phone was seized by the Heber. It's probably Heber. I'm probably saying that wrong. His cell phone was seized by the Heber City Police Department in a separate investigation, and the officers released it to Summit County Attorney's Office after the warrant was served to assist with the homicide case. A second search warrant was also signed on November 6th, granting law enforcement access to Richens Francis' home. Now, when it says Francis' home, she had multiple homes. Remember, she was flipping houses, so she may have owned more than one during all this. We know she owned that big mansion that she ended up selling. Investigators wanted to collect any and all documents, writings, or journals located on the Richens family home property, including in outbuildings, garages, and detached home offices. Corey is charged with 9 crimes, including 2 first-degree felonies, aggravated murder, and attempted criminal homicide, as well as several second- and third-degree felony charges of mortgage fraud, making a false insurance claim, and forgery. She needs to be charged for forgery for that book. 3rd District Court judge on November the 12th granted a request from prosecutors to drop 2 second-degree felony charges of distribution of controlled substances. We still don't know why they dropped that. Corey has been held in the Summit County Jail since her arrest, and an aggravated murder trial is set for May of 2025. The judge denied her defense attorney's request to consider bail in the November 12th hearing. We watched that. The judge did rule to sever the 2 mortgage fraud and the 2 felony forgery charges stemming from the incident in 2021 into a separate trial for the fraud allegations, which is actually probably good, and it cleans up things. I think that's better as far as for the jury goes. If the jury comes in and there's all these things that they have to look at and they can't concentrate solely on the murder charges, then it does make things confusing. So maybe that's why the prosecution decided to drop some of those charges. Now, of course, Richens and her family have maintained her innocence. With 2 charges dismissed and 4 others severed, the defense stands more confident. The case against our client is rapidly narrowing, exposing deeper weaknesses with each step, says defense attorney Catherine Nestor. So that's where we are with Miss Richens. It's getting closer and closer to trial, and we will see where it goes from here. And that, everyone, will conclude my update for this week. Thank you for watching. I appreciate you all being here. I hope you have a blessed day, and I will talk to you very, very soon. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.